Welcome. Today is Wednesday, March the 14th, 2018. This is a regular meeting of the Pitkin County Board of County Commissioners. To start off our agenda, do we have any additions or deletions?
There are no additions or deletions to the agenda today.
Okay, thank you. And now it's our public comment period. Are there any members of the public here wishing to speak on items that are not on today's agenda? Seeing none, I will bring it to the board. Does the board have comment?
That's fast.
Rachel?
Yeah, thank you. I just was going to let the board know that I won't be here for the next work session on the 20th and the regular meeting on the 27th and the work session on the 28th, 27th, taking a little bit of an extended vacation after the CCI meetings this week on Thursday, Friday. And I will be back in time to go to the Club 20 meetings on the 30th and 31st. So that's all I have, and I would like to wish everyone great luck with their March Madness brackets.
And then, Patty, under public comment, we had listed an introduction of Andy Mueller, who's the new general manager of the Colorado River District. He was not able to make it today, so we're working on a work session date. I think John Ely is working on bringing him in with the work session.
Okay. And Rachel, fly safe. Have a great trip.
Thank you.
And you really deserve a nice vacation, and I will be thinking of you.
Thank you. I appreciate that.
George.
Well, speaking of March Madness, there's been madness in Washington since last January. And I wonder how Trump would fare in a bracket. But things are looking better. Pennsylvania to Texas, and hopefully in Colorado come November.
You know, they do a bracket now for rock and roll bands, and they do one for Say Yes to the Dress.
Yeah, there you go.
So we could always fit him into one of those, too, if he didn't qualify for the other. Greg, do you have any comments for today?
Only
For tonight?
I was thinking when you mentioned March Madness, I thought about the marches today. I am so impressed that we've got school kids all across the country who are standing up and walking out of their schools to make a statement about gun violence. And I think it's great that they're finding their voice, and I think might this move the needle. And that I'm encouraged that people are re-engaging in civic discourse and civil disobedience in this case, and I think it's great that they flex their muscle and show the world what power they have. The other thing I wanted to mention just tonight is Cheetah Night is tonight at ACES. 5:30 tonight, we've got a conservationist who's working to protect cheetahs coming in from Namibia, and she'll be presenting at ACES. Hope you can make it.
Very nice.
On note for the kids in high school that are speaking out for gun violence, when I was in high school, we had a walkout so guys could have their hair longer than their collars, and girls could wear pants to school, long pants to school.
Stuff.
I know. We were very proud of ourselves. Steve, did you have any comments for today?
No, not today.
And Saturday is St. Patrick's Day, and the Catholic Church is having their St. Patrick's Day feast at Bumps. Is that correct, Craig?
Bumps. Yep.
So for those who are familiar with that, it's a long-standing tradition in this community. So eat your corned beef and cabbage and potatoes on Saturday night at Bumps.
And thanks Ski Company for stepping up and providing their venue.
Yes, yes. Okay, we're going to continue on with our meeting. First item on our agenda is a consent item, single reading minutes of the regular meeting of February the 28th. Does the board have any comments, corrections, direction?
I'll make a motion to move.
I have a motion. Do I have a second?
I'll second.
I have a motion.
And just to note that I did give 2 small corrections to Jeanette previous to the
Right.
meeting.
Thank you. Any other discussion? Seeing none, all those in favor, please signify by saying aye.
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 5 in support, Jeanette. Thank you. Next item is individual consideration, first reading. This is set for public hearing on March 28th. There's an ordinance authorizing acquisition of joint interest in the Red Hill Conservation Easement. Welcome, and please give your names for the public record.
Thanks, Patty. I'm Dale Will. I'm the Acquisition Director for Pitkin County Open Space, and I'm happy to have with me Suzanne Stevens, the Executive Director of Aspen Valley Land Trust.
Welcome.
Good to see you all.
And we are here today to talk to you about a proposed contribution of funding from the Pitkin County Open Space Program to AVLT's effort to conserve a 25-acre parcel on Red Hill. And I do have a map if you'd like one. Let's see. Hopefully, John, I won't get stuck trying to figure out how to get to it here.
Now, Red Hill's in Garfield County, is that correct?
Yes.
That is correct. And that's probably the most, the biggest nuance in this proposal. Oh, where'd the little cursor go?
Not the first time we've contributed funds for properties outside of Pitkin County.
It is not the first time. And, whoops. In this case, the Aspen Valley Land Trust has done, I think, an extraordinary job in putting together a consortium to do something that's difficult for a nonprofit to do. And because this property is used by many Pitkin County residents, particularly during the season when we've got Sky Mountain Park closed or some of our trail system is otherwise not available, we think that this project is of direct benefit to Pitkin County citizens. In addition, it's part of a scenic corridor along Highway 82 that's taken a few hits from developments outside of municipal areas, but the benefits to the rural character of the corridor will be enhanced by this project as well. The Open Space Board unanimously has recommended that you contribute $150,000 of our fund to this project. And at this point, I'm going to let Suzanne explain the details of how you pulled this off and how close you are to meeting your goals.
Okay. Well, thank you all for having us today and considering this request. This has been a pretty amazing project that actually began 10 years ago or more. We've made multiple efforts to acquire this property over time, and it's been quite expensive until recently. And we did manage to purchase it in December for $825,000. Our total fundraising budget that we're looking for is $1.35 million, and we are that close to getting there. So, but it's really been a community project. The town of Carbondale, Garfield County, some concerned neighbors, the Red Hill Council, which helps the BLM manage that entire Red Hill recreation area, all kind of brought us into the room and said, what can we do? This parcel's back on the market. It is commercially zoned, and there's been quite a bit of interest from developers in that as well. So we have been fundraising from up and down the valley. We've had support from Glenwood to Aspen. It's been a pretty unanimously popular project in that whether you're a recreationist or a neighbor who's concerned about public safety on the road or just want to kind of see the valley stay the way it is, at least at the entrance to Carbondale there, it's got appeal. So we're currently 190,000 short. If Pitkin County would consider this offer, it would put us basically within striking distance of closing out the entire campaign. And we do have funding from the River Valley Ranch homeowners who contribute to an open space fund for use within 7 miles of Carbondale that AVLT manages, and that is how we will fill any remaining gaps. So we're pretty excited to be on the home stretch. We hope to transfer this property to the town of Carbondale in the next couple of weeks and actually get started with the public process around trail planning to create this alternate access to the BLM area so we can get people off the county road and clear up some of the congestion and traffic that we're seeing on that road as a result of recreational traffic. We're very excited to have Garfield County's support. They've been very active and involved the entire time. They've committed funds from their Conservation Trust Fund in 2019. And we'll also be putting in additional funds, most likely, toward trailhead parking and possible road realignment. So they've been great partners. Town of Carbondale is very excited. They have minimal financial resources, but they have contributed $50,000 as well. And they, of course, will be taking over management. So Pitkin County Open Space and AVLT will co-hold the conservation easement if you do agree to put funding toward this. And that's the summary. Any questions? Yeah.
Great, go ahead, please.
So were you saying that if we take the plunge, then RVR has a fund and they'll fill in the gaps? Is that the final?
It's
bring in the final-
ABLT's fund that's contributed through an RVR transfer tax, but yeah, we'll be about done. So
If we
can
pull the
fill
trigger
it in.
today, it's done.
Yeah. Yeah.
Excellent.
Steve.
And why wouldn't we?
We got Garfield County in a deal
Sounds
here.
like a good idea to me.
Steve, go ahead.
I want to know how this will affect the parking area there at the bottom of the county road. That's one of the few parking areas in the whole Roaring Fork Valley that is not a RAFTA parking lot. We have used it for like meeting a friend there and leaving a car, that kind of a thing. Have used it to park and go hiking up to Mushroom Rock
Yep.
a
Everybody
few
does.
times.
Yeah, great
But
question.
if that parking lot could be expanded as a consequence of this purchase and maybe realigning the road, so is that in the works?
That is in the works. That'll be, just to be totally clear, that will be beyond AVLT's purview. We'll stay involved through the trail planning part, but once the town of Carbondale takes ownership, then the construction of a new trailhead parking lot and adjacent to the existing parking lot and road realignment would be between the county and the town to work out. So I don't want to make any false representations at this point, but that is absolutely in discussion, and I think that's pretty key to the whole, basically the concept from the beginning has been that we need additional parking there.
So does it give them more, would they potentially be putting the county road onto that corner of the ABLT property?
Yeah, I don't have a pointer here, but if you look at where the existing,
Use this guy.
okay, yeah, this will work. Here's the existing parking lot down here, and this is what you're referring to. And there is some serious congestion in this parking lot as it is. It's, I'm not going to call it a disaster, but I might.
It has a difficult layout.
Yeah, it's a very unusual shape. It gets very congested. The county road actually swoops through like this. So I think the ultimate goal of the county and CDOT, who actually owns this purple piece of land here in between our property boundary and the parking lot, is to just actually cut this off right here and realign the county road through that chunk of CDOT land, and then create additional trailhead parking over here on this lowest bench of the Red Hill property that would be on highway grade or slightly below. And in so doing, you'd actually free up a little extra space here because this, what is currently road, could be added into parking, and you would not have people accessing the parking lot via this sort of frontage road here. So that's what's been discussed. Again, that'll be subject to planning processes and county and CDOT. So no promises as to how that will look, but that's anticipated for 2 years from now. So this summer we would get started with the actual trail planning process and construction itself. And RFOV has committed to do the pedestrian trail, which is anticipated to go up this hillside and connect into the Mushroom Rock trails. And then the additional trail, which would be a wider general access trail, would kind of come up the gulch and hook into the existing trailhead.
Popular area.
Yeah.
George?
Yeah, Suzanne, I'm really want to praise AVLT for taking the leadership on this and bring together partners to make this happen. And I would encourage AVLT to continue to seek out opportunities, especially along the valley floor, the Roaring Fork Valley, when you see opportunities to preserve open space, if it's not necessarily for recreational, but just given all the development that's occurring, and to use AVLT status to bring partners together for future projects.
Absolutely. Yeah,
Careful what
that's
you
our
wish
goal.
for.
Thank you. Maybe back at your door. before-
Any other discussion? Questions?
Who wants to make the motion?
I would like to have a motion, please.
I'll make the motion to the ordinance authorizing acquisition of a joint interest in the Red Hill Conservation Easement.
Second.
I have a motion, a second, and this is set for a second reading public hearing on March the 28th?
Correct.
Correct? So I have a motion, second. Any further discussion? Seeing none, Steve.
I turned my page and I have something marked in yellow. On the second page of the ordinance, it says approximately 20 acres in item number 1. And then it's always been touted as being 25 acres. So should it say approximately 25 acres?
We could write in 25. That's my bad, and I was trying to finish the ordinance without notes and then went back, so
we'll
I should have caught that.
So maybe we could just say the exact acreage instead of approximately.
There you go.
In that.
So I need an amendment to my motion to change, correct item number 1 on page 2 of the ordinance.
So moved. I could do that.
So you are the motion maker, so Steve, you were the motion.
And I'll second that.
So I'm going to vote, I'm going to call the question on the amendment. All those in favor, please signify by saying aye.
Aye.
Now I need to call the motion. All those in favor, please signify by saying aye.
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 Motion passes 5-0. Thank you.
Thank you very much. I will be out of town on March 28th, so I won't be back for the public hearing, but I really appreciate
We will have you in mind when we
Okay.
pass it on second reading.
Excellent. Thank you so much.
Jeanette, did you
Thanks,
catch
Suzanne.
all of that?
Congratulations, Suzanne.
Thank you. Next item. Next item on our agenda, individual consideration items, public hearing. This are second readings. We have a budget resolution for the Phillips Mobile Home Park. Connie? Nice to see you.
Good afternoon. Thank you. Good afternoon. Connie Baker, Pickens County Budget Director. This is the second reading for a budget resolution to appropriate the funding for the purchase of Phillips Mobile Home Park. It does increase the budget of the housing fund by $6,790,000. The majority of that is for the purchase of the mobile home park, $6,450,000. There is also $200,000 included for 2 different consultants, one that will be doing site work on the property and the other working on designing a sewage plant with budget for the construction of a new sewage plant coming later in 2019. The other part of the budget resolution includes funds for a property manager for 10 months of the year, March through December, and that's a contract that then would continue into the following year, with the remainder being budgeted in the 2019 budget. And some money also for the property maintenance and repair in case there are some additional costs that might go along with that property manager position.
So this actually cleaned up the issue with the manager from our last reading.
Right. So we've got it all corrected to just a contracted service.
Perfect. Thank you. Any questions for Connie? Steve?
Connie, on the line that says property acquisition, it ends up with a revised budget of $7.95 million.
Yes, that's because the 2018 budget does include funds for other projects in the housing fund. So the revised budget is not all for Phillips.
Oh, okay.
The $1.5 million would be for other projects that the housing fund is looking at, for example, Basalt Vista.
Okay, that explains it. Thank you.
Anyone else? Do I have a motion?
I would move
Oh, wait.
to,
Go ahead. This is public hearing, but I'll call it after the motion.
okay, I would move to approve the budget resolution for Phillips Mobile Home Park.
Second?
I have a motion and a second. This is a public hearing. Are there any members of the public wishing to comment on this item on our agenda? Seeing none, I'm going to leave the public hearing open and call the question. All those in favor, please signify by saying aye.
Aye.
Aye. Motion passes 5-0. Thank you. Thanks, Connie. Next item on our agenda, resolution authorizing approval of a cable franchise agreement with Comcast of Colorado. This item is continued from February the 14th. Hi.
Hello, Kara Silbernagel with the manager's office. As Patty mentioned, this is the second reading of the franchise agreement with Comcast. It was continued from the prior meeting because there was some miscommunication in reviews between Comcast, and ultimately we worked through negotiations, and what we settled on was kind of coming back to where we are today, which is where we were before. So kind of came full circle. But minor changes is when we did this last time, it was Pickens County, City of Aspen, and Town of Snowmass Village did a joint negotiations with Comcast. This time we added in the town of Basalt, and as we worked through it, we found there's just some technicalities of how the head end of the PEG stations work. And so, as you may be aware, Basalt has channel 17 to stream their live meetings, but then they get replayed on on CGTV, and Grassroots is always also shown down in Basalt. So we just had to work through with Comcast and some of their technical folks of how to ensure that the channels that are in City of Aspen, Town of Snowmass Village, and Pitkin County, being CGTV and Grassroots, are also committed to being down in Basalt. And so we got that language clarified in section 9.2. And then the only other change from first reading was we caught that it had the uniform building code instead of the international building code. But otherwise, we, if approved, we'll move forward, and we'll have 3 standard definition PEG channels, and then we'll have, over the next 2 years, move to also have 2 high definition channels available for the viewing public, and those 2 channels will be Grassroots and CGTV.
Kara, was there not also an issue of monies coming back to the county that now are broader based with equipment and rather than just?
So yes, there are the subscriber fees, which is staying the same for Pitkin County. Town of Snowmass Village and Town of Basalt have increased their subscriber fees, so now we are all on the same level, which is 50 cents, I believe. And that is pushed through to the end user. Comcast has that ability, so that will be to the end user. But that is staying the same for Pitkin County. And then jointly with all 4 of us working together, we've received a $20,000 grant, so $5,000 per community to work on equipment to provide on-demand services via the internet. And so once we finalize this agreement, we'll move forward with that equipment purchase and work with Grassroots and all the different jurisdictions to get that up and running.
Great. Yeah, Greg, please.
Question, is there a budget for that, the on-demand equipment? I'm just wondering, do we know what the cost will be to actually create that service, or will it be covered by this amount of money?
We do not have a budget at this time, yeah.
Okay.
This was something that has been common in other recent franchises agreements, and so we pursued this with Comcast, and we'll have to work towards that.
Got it.
Any other questions or comments? Seeing none, this is a public.
I just have one. Andy Davis, who is the Comcast Government Affairs for the Mountain District, who was our contact with Comcast, he sends his apologies. He has also been struck by the cold.
Oh, no.
And so he apologizes. He usually likes to come to these meetings at least once in person, but did offer up, if the board would like, he'd be happy to come at a later date and just kind of share an update with Comcast, bring the local operations folks so people know who to contact, and kind of just share what Comcast is doing.
We can work that into a work session with John. If that would be
Okay.
great at some time in the future. That's nice of him to offer.
Okay. Yeah. So
This is a public hearing. Are there any members of the public wishing to speak on this item on our agenda? Seeing none, I'm going to leave the public hearing open as we move forward. I need a.
I'll move to approve the resolution of the Pitkin County Commissioners authorizing approval of cable franchise agreement with Comcast of Colorado and other states, LLC.
I have a motion.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll call the question. All those in favor, please signify by saying aye.
Aye.
Aye. Motion passes 5-0. Kara, thank you.
you guys.
Thanks, Kara.
All right, next item, moving along, thank you very much. This is an individual consideration item. This is an emergency resolution confirmatory reading. I think you're taking this, are you, John? And this is also, I need to open the public hearing. We'll keep the public hearing on this moving forward, because this item is going to be continued till March 28th. It's an emergency resolution repealing resolution number 69, 2017, and approving an intergovernmental agreement between the Board of County Commissioners of Pitkin County and Arapahoe County for GovPrime.
Thank you, Patty. This is a agreement with Arapahoe County to use software that Arapahoe County developed that creates a better interface with the state human service systems software. And so We had to change some elements related to, I believe, the insurance on the original intergovernmental agreement that the board approved. We brought this forward as an emergency resolution so that it could be in effect immediately, so that we could schedule time for training and implement the software in a timely manner. So again, this is a confirmatory reading. I believe our initial outlay is not coming up here, but it's somewhere in the neighborhood of $2,400 in the first year. So it's a small amount of money that we're paying to Arapahoe County for use of the software.
My question would be, why are we continuing? If we had an emergency.
Noticing.
What's that?
Noticing.
Oh, noticing, okay. I was just wondering, we were pushing it through, so noticing, but this is a public hearing, and I need to open it for any members of the public who may have come today to speak on this item. Seeing none, I'll bring it back to the board. We need a motion to continue this item to March 28th, 2018.
Move to continue
Thank you.
till March 28th.
Second?
I have a motion, I have a second. Any further discussion? Seeing none, I'll call the question. All those in favor, please signify by saying aye.
Aye.
Motion passes 5-0. We have continued. What? Okay. This next item is a land use public hearing. This is a resolution finding that it is not appropriate to grant relief to Celestial Land Company for the automatic stay imposed by Section 2-20-10 of the Land Use Code when an appeal is filed and extending the stay until a final non-appealable decision is issued on the Appeals Board of Adjustment Resolution number 10, 2017. Suzanne, please.
Give me just a second, I'll just pull up the map for you.
Okay, while you're doing that, I'll let the public know. This is also a public hearing, and when we get to the point of public hearing, we'll see how many members of the public wish to speak. We will have a time limit on public hearing, and we'll just see how it goes with how many members of the public are here to speak. Hi, Stan.
Doing fine.
We're traveling through
usually
the...
it just goes straight there. Yeah. This doesn't want to highlight it, but okay. That gets us close. Okay. There you go. Get a pointer on it. Suzanne Wolf with Community Development. The request is from the applicant being Celestial Land Company, represented by Stan Clausen and others, who Stan can introduce, is requesting relief from an automatic stay imposed by Section 2-2010D1 of the Land Use Code, which prevents processing of building and other development permit applications and an application that was in process for reinstatement of vested rights for the property. I quoted a lot of code sections in my memo. I'm not going to read all of those back to you. So, but unless the BOCC provides relief from the stay that is in effect, the stay would continue until the issuance of a final non-appealable judgment or order. There is an appeal in process related to a Board of Adjustment variance back in September. The Maroon Creek Caucus and a group of neighbors appealed that decision. That appeal is what enacts the stay. So the appeal operates as a stay. The appeal, both of those appeals of that Board of Adjustment variance are scheduled for consideration by the BOCC on April 16th, 2018. So lots of background I also put in my memo and will not walk you through. I think you're all aware of kind of the extensive history of the development approvals on the property. I guess cutting to sort of the more recent time frame, the applicant did, so that the board approved the site plan, et cetera, for Celestial back in 2014. Last year, 2017, the applicant did commence the permit process and started to come in with building permit for retaining walls and the debris flow structure, access earth moving permits, a building permit for the residents. Those were all started in our process last summer. As part of that process, it was identified that variances were required for some of the grading within the setbacks. That application was submitted and heard by the Board of Adjustment in September. And that's where, and then the appeals resulted from that. Meanwhile, the vested rights did expire on July 21st, 2017 for that 2014 approval. Given that the permits were in process, starting in the process but had not made it through the process, the applicant decided to submit a request for a reinstatement of those vested rights to maintain that vested right during the time frame of getting through the permits through. That request was also stayed by the appeal. So those are the things that are subject to the stay. As I mentioned, I quoted the provisions from the code related to the stay and how relief can be granted. Basically, it provided that once the applicant submitted, the stay has been in effect since the appeals were submitted. But the applicant didn't submit a request to lift the stay until January 29th of 2018. At that time, basically, the code says there's a 60-day period that if the board takes no action, the stay would terminate automatically. So the board has to extend that stay if it wants the stay to remain in effect. Otherwise, it would terminate. Let's see. So your packet included the request from the applicant. It also included letters from the neighbors represented by Michael Sawyer, and also a letter from the caucus, both requesting that the stay remain in place. And then just from staff's perspective, we consulted and worked with the county attorney. We're recommending that given the time frame, the appeal is at this point just a month away, that it's basically appropriate to continue the stay until that appeal has been considered and a determination or decision issued on that appeal. With regard to processing permits and moving permits forward, the grading is integral to the whole development plan. It accommodates the driveway and the required mitigation structure. So they need the variances in order to proceed with those permits, which affect the building permit. Everything's tied together related to that. So it definitely doesn't seem appropriate for us to be moving those permits forward through the process when there's a question as to whether those, what will happen with those variances. So that will be the hearing before you on the 16th of April. At this time, the reinstatement of vested rights had been scheduled, I think back in October. It had originally been on your schedule. That was a noticed public hearing that has been continued several times given the stay. So it has most recently been continued until April 25th, 2018. So you wouldn't be hearing that request until after that appeal. I guess the question would be whether the appeal is resolved or not at that hearing. We don't know at this point, but that has been continued out till the first regular meeting after that appeal hearing. So our recommendation is that the BOCC extend the stay until the BOCC issues a final non-appealable decision on the appeal.
George, please.
Thanks, Suzanne. So today, the issue we're going to hear is specifically just on the stay. We're not going to be hearing anything regarding the appeal.
Correct.
Okay.
Right, so no merits of the appeal will be discussed.
Great, just so it's clear to everybody in the audience.
Yeah. Any other questions for Suzanne?
I'm sorry, I didn't point out the property if you wanted me to do that. Stan put the arrow on it, but again, for the public, Maroon Creek Road here. Sorry, it's not driving very well. Bulkley Drive, and then this is the Celestial property, which is a 35-acre property, but basically the development area is down here adjacent to Bulkley Drive.
Thank you. Stan, would you please introduce yourself and anyone else who will be speaking on your behalf?
Thank you. Stan Clausen, for the record, Stan Clausen Associates, representing Celestial Land Company. With me is John Fogliani, attorney from Fogliani and Fote. Hayes Boone, I'm sorry, their new name is Hayes Boone. And he will also speak, and there may be some others speaking, but
they can introduce themselves at the time.
Principal speakers.
Thank you.
So if I may, just to go back to the county code, the county code provides two bases for relief from a stay. And one is, and I'll just read it because I think it's helpful to have it in front of us, for cause, including lack of adequate protection of an interest in property, or finding that the appeal, litigation, action, or other proceeding will not alter, amend, or void a previous determination or action pursuant to this land use code. That is A. And B, if the board finds that the filing of the appeal, litigation, action, or proceeding that gave rise to the stay is part of a scheme to delay, hinder, or defraud an applicant or other party that is based on the evidence presented to the board, the appeal, litigation, action, or proceeding is frivolous or groundless. We believe that both of these provisions within the county code have merit with respect to our request to lift the stay. We have had numerous approvals over the years, some of which Suzanne detailed. This was a project that was originally approved by the Board of County Commissioners prior to site plan review. It required going under site plan review. It's a project that's been on our books since 2006 for a single-family home. It was approved by one hearing officer, and that was appealed. It was approved by a second hearing officer, and that was appealed. It was approved by the Board of County Commissioners, and that was appealed to district court. And district court upheld the Board of County Commissioners' approval. It then required some zoning variances as detailed engineering proceeded after the final plat filing. The Board of Adjustment voted 5-0 to provide those zoning variances, feeling that they were consistent with what had been approved by the Board of County Commissioners. That has been appealed. We believe that this is very definitely an action or proceeding that is a scheme to delay, hinder, or defraud an applicant, and that you really should look at it as this. I have, for example, a statement from the Maroon Creek Caucus that's part of your February 28th materials. And it says at the bottom of the first page, obviously, developers' plans are seriously at odds with our newly adopted plan. That means adopted by the caucus, but still in consideration by the county. Indeed, the entire purpose of time limits on vested rights approvals are exactly because the community might decide to enact a master plan like ours. You can impute from this that the delays and the attempt to continuously delay this project is to somehow run out the approvals. We don't believe that's really possible, but that is the intent. And we feel that being able to provide an extension of vested rights, which is also provided under the code, is perfectly appropriate because of the some 20 months that took place while it was being heard by the district court. And we also feel that we had began and made good progress with a county-appointed consulting engineer to look at the plans for the debris flow basin for all the aspects of the project. There had been a number of requests for information submitted by the county consulting engineer that had been responded to by our engineers. In other words, we had a process going, and that process has been completely interrupted. Now, no one expects that until this Board of Adjustment appeal is resolved, a building permit can be issued. That certainly is not something that we expect or would consider. On the other hand, we feel it is perfectly appropriate to be able to continue this process with the county engineer to look at our project, to have this exchange of information that is part and parcel of any detailed review of a building permit application, on one hand. On the other hand, there is absolutely no reason that a stay should affect our request for an extension of vested rights. That has no basis in terms of whether the appeal might result in some change to the Board of Adjustment's approval. We also felt in some discussions with the county attorney, and we would ask that this be made part of the record, that this could be bifurcated. And if you did not believe that lifting the stay was appropriate for the building permit processing, you could determine that it was appropriate to lift the stay for purposes of the extension of vested rights. Now, Suzanne has indicated correctly that the extension of vested rights is intended to be considered on the 25th of April. Seems like a short time, but let me tell you how long this process has gone. The county has wanted to be very forthcoming and careful with the opponents so that when we initially had the appeal lodged, there were a number of dates, some of which were months previous to this, February dates. And the opponents said, no, we can't do that. We can only accept an April date. And that April date was then modified a second time to be further out. We don't know what sort of delays will be incurred with the opposition on the 25th of April or on the 16th of April. And so we believe that processing the request for an extension of vesting is perfectly appropriate because of the uncertainties that surround this. We also believe that processing the building permit application to the extent that the consulting engineer for the county is permitted to continue to do his work in relation to our engineering staff will be very helpful and will remove or help to remove some of the harm that's been done in terms of the delays. I would repeat, this is a 2006 process that has been appealed again and again and again, even though it's been reaffirmed by 2 hearing officers and the Board of County Commissioners and the District Court. I don't really feel that it's necessary to go on with a lot of additional code-related material. I'm happy to answer any questions, and I know John Foyani is here to add to my presentation or to answer any questions as well.
So Stan, let me just see if the board has any questions directly for you, and then we can. George, please.
I have a question more for Suzanne, just to clarify regarding vesting rights. I thought that if a application has a vesting rights, but that during that period of time, if that proposal gets tied up in court or is involved in a stay, that the vesting rights don't take into account that time period.
We grant a 3-year vested right with the approval. When, in a request for an extension of vested right, that can be part of a consideration. If it was, unable to move forward with that approval based on that for a period of time, that could be part of that consideration for that extension. But up front, they are granted a 3-year vested right.
Yeah, I know, but I thought, I kind of remember a case in the past where there was a case that was held up in court, and that time period that was held in court did not count as
Did not
part
apply
of
to the 3 years?
Did not apply for the 3 years.
That would have to, again, the vested right gets specified at the time of the approval, so it would have to come back to you in some form to have that be accounted for in terms of shifting that vested right or extending it.
All right, so it would come back to us just to take into that account, and the board can make that adjustment if they wish. Great, thank you.
So in other words, the vested rights, the extension request for vested rights will just be continued out. They will not lose their extension of vested rights opportunity until such time as we hear it on the 25th when we make a decision on the extension. Is that
I
correct?
mean, right now, the vested right expired in July.
Right, but they filed it timely.
They filed and then, have asked to reinstate.
They're in the
or
timely manner of
so-
which to process their request
so
for an
that's-
extension.
That is in process.
Yes. So we're okay on that level with their extension of vested rights request being able to be heard on the 25th of April.
Correct.
The board have any other questions? Stan, please.
If I may, the extension of vested rights would be able to be heard on the 25th of April,
Right.
Not with
providing that there is a definitive resolution to the appeal on the 16th of
Right.
April.
Well, that is our plan, is to hear the appeal. We've gone to great efforts and frustration to try and schedule that when all members of the Board of County Commissioners will be present. So right now, we are set for the 16th, barring any unforeseen circumstances at this time.
And that is very much appreciated. Thank you.
We're doing our best, Stan. Okay, thank you, Stan. You can continue, please.
I would turn it over to John Fogliani, who may have some additional comments.
John, if you just give your name for the record so we have it on tape.
Sure.
Thank you.
And yeah, the microphone's in our temporary office here.
Yeah, Suzanne, would you just shift that mic a little bit for him?
I'm afraid to touch them after last meeting.
John Fognani, appearing for Celestial Land Company. Last name is spelled F as in Frank, O-G-N-A-N-I. I think Stan has very completely explained the situation to you. A couple of points that I think are worthy of reiterating. Number one, we've already filed for our permit, our building permit. We filed the application. My understanding is that the application has been deemed to be complete. There have been a request for comments that we were prepared to respond to, but then the stay was put in place that prevented that response from going forward. Number two, we filed for our reinstatement or the extension of the vested rights in a timely manner and consistent with the land use code. So that clearly has been done. And what we're asking for today is obviously lifting the stay so that we can complete the application for the vested rights matter, which has been timely filed. The other thing I think is worthy of comment, we're not asking for the stay to be lifted completely, and I think it's within this body's authority under the land use code to either condition or modify the stay in some respect, and I'll give you a suggestion as to what I think could be done. Since we've already submitted the application for the building permit, and since we were in the process of commenting back to questions that were posed to us with regard to the permit, and we had our engineers and construction people poised to do that, my suggestion would be to leave the stay in place with regard to the building permit itself so it does not issue until we get the remainder of these issues addressed and resolved, but allow the process to go forward so that we're not behind the 8 ball again 2 or 3 or 4 or 5 months down the road. It seems to me that since the permit application has been filed, since there have been questions back, that process can be allowed to go forward by lifting the stay with respect to the remaining aspects of the process to be dealt with. And then at the end of the road, the stay would be in place with regard to the actual issuance of the building permit. That seems to be a hybrid determination that's fully within this board's discretion to grant under the land use code, and something that we would request that you entertain so that we can keep the process moving. As Stan mentioned, there's been one delay after another. You can reach your own conclusion whether the delays have been appropriate, whether they have hindered the process consistent with what the land use code says. But certainly this process has been going on for multiples of years now, and it's time for us to move it forward. So if we could complete that element of the building permit application during this time period, that would be very helpful. Again, it's something that's within your authority to grant, and then we can await the determination of the building permit itself.
Thank you for the clarification. Any questions from the board? No, thank you. We can move forward.
Thank you.
Stan, do you have anyone else?
No,
Okay.
but we're happy to answer any additional questions that you might have.
So does the board have any further questions, comments? I can open the public hearing. So I'd just like to see a raise of hands. How many members of the public are wishing to speak on this item today? Okay. I'm going to just kind of be a little lenient, seeing that there's just a few. So if you'd like to just step up to the podium, I'm going to keep it within a reasonable time frame. So if you see me like looking at you in a strange direction, it means to kind of wrap it up. So who would like to proceed first? Jump right in there. Just give your name for the record, please.
Hi, I'm Adelaide Waters, and I represent the Maroon Creek Caucus. And I just want to say that I, as a resident, appreciate your willingness to rehear the variance that was requested by the BOA. And as we didn't feel that we were necessarily heard or that a decision had been made even prior to that meeting, so we appreciate you considering it again.
Thank you very much.
Thank you.
Appreciate it.
My name is Mike Sawyer. I'm an attorney with the firm of Karp New Hanlon, and I represent a group of neighbors of the Celestial property. I think that staff has properly analyzed the request to lift the stay. I would just note at least one factual disagreement with Mr. Clausen. It has not only been the neighbors who have scrutinized and appealed prior determinations, but Celestial also made an appeal of a prior determination. And in fact, after that appeal was heard, the matter was remanded because this board determined that an improper standard had been used in processing the prior application. So it is not merely the neighboring landowners and the public who have desired to see this matter thoroughly vetted. It's also been the applicant. I guess I would just note a couple of small points relative to the request to lift a stay. The applicant has suggested a bifurcation that perhaps the stay could be lifted as to their request for processing their reinstatement of their vested rights, but not as to the building permit. I don't think your code allows for that. Under 2-20-10 D1A, this is with reference to the stay. It says the acceptance, processing, or issuance of any and all building applications or permits, development applications or permits, development approvals, or any other county action which would permit or otherwise authorize construction, site work, grading, land improvements, or creation of a vested right. I don't think you can bifurcate this. Your code doesn't permit that. I guess the only other thing I would say is that with regard to the written submittals from Celestial, initially they had been honing in on the fact that the variance appeal would not necessarily implicate or overturn the prior BOCC determination on the site plan and activity envelope designation. And I just, again, without going into the merits of the appeal, which we'll have an opportunity to discuss with you at a future date, we do believe that as part of that appeal, there is in fact an issue relative to that prior approval that needs correction by this board. So again, we have an appeal hearing that is about a month out. I think you will find at that appeal hearing that the neighbors have several very legitimate concerns. And we look forward to you making a determination on this particular issue consistent with your code and continuing the stay in place until after that appeal of the variances has occurred. Thank you.
Thank you very much.
Any questions?
Does the board have any questions here? No.
Public comments. No.
Public comment.
Yeah, okay.
That I was going to offer it, George. Any other members of the public wishing to speak? Barbara, please come up and give your name for the record.
I'm Barbara Convisor, and I have been a resident of this valley, of Maroon Creek Valley, for more than 48 years. I truly appreciate all the care and time and labor that staff, board has put into this, and wanted to thank you for that. I think it's such an important project that is being contemplated that I can't understand why anyone would question delaying and just putting it off until all the I's are dotted and people know what's really going on. Thank you.
Thanks, Barbara. Marcella, please.
Good afternoon. I'm going to be very quick, as promised. I'm Marcella Larson. I am the moderator of the Maroon Creek Caucus, and you've already met some of our caucus members. Also in the audience is Jason Ludington and Vita Ludington. I think you've heard from them before. And we're not going to comment beyond our prior objections to limiting the automatic stay, except for we want to say that we fully support staff's recommendation. We think it was well thought out. And we commend the board for insisting on order in these proceedings. That's going to be very important as we proceed. I was somewhat distressed, of course, as a caucus member who's been working really hard on a master plan, and our whole group is to be sort of subjected to the kind of criticism that we've heard here today. And I hope that we will have the opportunity to speak fully about our master plan goals. We've worked hard on it. It's taken a long time for us to come to the point where we are right now. And I also wanted to mention that there's some precedent, the developers arguing for this bifurcated process, and I agree with Mike Sawyer that the code doesn't allow it, but this whole vested rights thing is a very important issue because that is also another judgment that might have to be appealed somewhere else. And there is precedent in terms of your staff recommendations recently in terms of the Redstone Castle and Highlands Ranch, where staff has recommended against extensive vesting because there were master plans in process. So with that, we really hope we're going to be able to make substantial progress on April 16th regarding this matter, and we appreciate you hearing us today.
Thank you. Are there any other members of the public wishing to comment on this item? Jeanette, I have a question for you before I close public. Does our last item on our agenda today, is it a public comment item? The land use actions? It doesn't note anywhere. No. Okay, then I'm going to close the public hearing because I did continue the public hearing for the item that we continued. Okay, so no members of the public. Stan, do you have some comments before I bring it back to the board?
I got a question.
George, yeah.
Just a question for Rye, our attorney, because it was noted that our code does not allow the opportunity for the bifurcation of this request. What is your take on that?
Sure, George. Actually, 2010 D3 does provide that upon request of a party in interest, at this point that would be the Celestial Land Company, this board may terminate, annul, modify, or condition the stay. So if this board felt it was appropriate to make a modification to the stay, that essentially bifurcated the two issues, the vesting rights and the building permit, I think they could do that under the code.
All right, thank you.
How does that contradict the code section that said that vested rights couldn't be part of a bifurcation?
Well, there isn't a code section that specifically says it couldn't be part of a bifurcation.
Okay. All right, so it is an opportunity we could consider.
Yes, you can consider that.
George, good question. Any other members of the board have questions before I let Stan proceed? Steve, you're okay?
I do have a question, and it probably would be either for Rye or for Suzanne, having to do with the process for Celestial applying for the extension of the vesting rights, and then the process whereby it was continued to various states and now has been, I presume, continued to April 25th. So it was this, the whole chain of them applying was done in a timely manner, and then our process of doing the continue the hearings was all done in a timely manner. Is that correct?
Yes, that's correct. They applied, let's see, August 17, 2017, they submitted their application related to the vested rights, which was prior to the Board of Adjustment hearing. So when we received that application, it was scheduled for a public hearing on October 11th. So then there was the Board of Adjustment hearing, the appeals enacted the stay. So then that hearing, you did not hear it on that date, but you continued it on that date. And we've, I think, had 2 other continuances since then as we were waiting for this appeal process to play out.
So all processes have been done in a timely manner as to not invalidate any step along the way.
So I take that to mean then that their application to extend the vesting rights is not in jeopardy by waiting until April 25th to hear it at that time.
It is still, it's active. The only reason it hasn't moved forward is because of the stay.
Yeah, okay.
Been
Thank
considered.
So they're still in good standing for that. Any other questions before I let Stan? Stan, would you like to continue?
Well, my comment was going to be the one that Attorney Neely dealt with. That is that you have a very clear statement within the code that gives you the opportunity to terminate, annul, modify, or condition the stay. I'm not an attorney, but that's the plain language of the code. So I think with respect to the stay, with respect to bifurcation, with respect to conditioning it in some way, you're at liberty to do whatever you think is most appropriate. The other thing I would simply say is that we have, in response to a comment that suggests that we have vilified anybody, we have tried to keep our discourse on perfectly appropriate and high level consistently, and we will continue to do so.
Thank you, Stan. Appreciate that a lot. Okay, bringing it back to the board. Suzanne, do you have anything else before I bring it back to the board? Okay. We're okay bringing it back to the board for discussion? Okay. I'm bringing it back to the board for discussion. Rachel, please.
Thank you. I have to pick these up by the base. In reading through this and then thinking about the experience I've had over time at this table or others, I can't help but feel that lifting the stay ends up kind of putting the later decision in a kind of a biased light, and that's just my impression. But I lived through the St. Regis, Ritz-Carlton battles, and it was the applicant wanted to proceed at risk, even though he knew he was at risk. But it suddenly raised all these fairness questions: is it fair to deny now since he's been proceeding at risk? And so it feels very much like getting the proverbial cart in front of the horse. When there is a hearing already set that's scheduled for literally 5-6 weeks from now, that will determine the appropriateness of the decision of the BOA. And I just can't weigh in to say, okay, we'll lift the stay, you can start proceeding, because to me, it starts to almost feel like a summary judgment, that we've kind of decided this is going to go forward, this is kind of fine, without even hearing the evidence in the other hearing. And so for those reasons, I believe our staff has done good work. I think they've been very thorough in analyzing this. It is a complicated matter, there's no question about it, but I agree with the conclusion that they reached, which is the resolution in our packet.
Thank you, Rachel. George, please.
Yeah, I would agree with Rachel's comments. The comment that was made that this may put the applicant back behind the time frame for 2, 3, 4 months down the road. I don't think that's the case. I think it's the intent of this board to hear this appeal in just a few weeks and make a determination. And so given the short time frame between now and then, I would just hold that the stay be extended until that meeting, along with the issue with the vesting rights, and we resolve that at that time.
Any other members of the board wishing to comment? Steve, please.
I would concur with both of your statements. Just a few short weeks will make a determination, and rather than change the process right now, that I think would muddy the waters more than it would make it easier. And we're basically, by denying their application to asked for the stopping the stay, we are actually following our own land use code and upholding that. So that's my position.
Great.
I think I'd agree with what Steve just said about following our own rules, and I concur with the others as well.
Yeah, I'll just add a comment. I believe moving the process forward as we have planned to do so, and we will continue to do so in its most timely manner that we can. I think it's most appropriate for us to stay with the stay as it currently is written. So I'm going to bring it back to the board for any further discussion or a motion, please. Rachel?
I will make a motion to approve a resolution finding that it is not appropriate to grant relief to Celestial Land Company from the automatic stay imposed by Section 2-20-10 of the Land Use Code when an appeal is filed, and extending the stay until a final non-appealable decision is issued on the appeals of the Board of Adjustment Resolution number 10-2017 by Suzanne Wolf.
I'll second.
I have a motion, I have a second. Do I have any further discussion from the board? Rye?
Patty, I was just looking at the resolution that Suzanne drafted, and she had actually sent it to me the other day to look at, and I just would ask or suggest that paragraph 20 of the resolution be amended to include a reference to section 22010 D4. It currently includes D3, but D4 is actually the provision in the code that gives you the ability to stay or extend this stay.
So
I missed it the other day when she sent it to me.
So on page...
I will amend my motion to include a reference to the provision of the code granting authority for this decision, which is 220-10D4.
Correct.
So that is number 20 on page 3 of the resolution. So I have a motion to amend.
I'll second.
I have a second. I'm going to call a question to amend it first, and then I'll call the question. All those in favor, please signify by saying aye.
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 And then I have a motion to approve the resolution now as amended. I'll call the question. All of those, please signify by saying aye.
Aye.
Motion passes 5-0. Thank you, Rye. Thank you. Thank you very much.
Thank you. And
We will see you on the 16th.
I appreciate very much your statement that the board wants to move this forward expeditiously.
Yeah, and we will, we're right now, we all 5 will be here on the 16th. All right, next item. We have one more item on our agenda, and this item is a resolution approving an extension of the deadline to record the Soldier subdivision final plat. And I think Dale, are you, Dale and Suzanne, or? Come on in.
Come join me. Sure, why not?
All right, thank you.
Okay, Suzanne Wolf again for Community Development. The request is to extend the deadline to record the plat. The board approved a final plat for a 2-lot subdivision of the Soldner property. Do you want me to pull it up?
Gentlemen, we're continuing our meeting. Thank you.
Let's see if I can get it up quickly.
Greg, it appears that I'll get you to the cheetah show.
I'll say. I don't have time for a nap.
What?
Now you've done it.
Yeah.
Okay. So here's the Soldier property. I'll backtrack and point out where we are. Highway 82, Stage Road, Maroon Creek Club. Here's
Harmony
the Soldier
Road.
property. Harmony Road, back to Burlingame. So this approval has been granted to subdivide this lot into 2 lots, one containing the existing compound, the Soldner residences and studios, etc., and then a new lot to accommodate 1 single-family residence. Since that approval was granted, Stephanie Soldner for the limited partnership for the family has been working with the Open Space and Trails Board and various other entities to see if she could find other solutions for the property besides creation of a residential lot to sell. So we, the Community Development Department, have granted a couple of extensions of the deadline to file that plat. Administratively, the last time we did it in September included a statement on the bottom that if there was to be another extension, it needed to come in front of the BOCC for approval. So that's why we're here. And that was just sort of to see how these processes continued, and we felt it was appropriate at a certain point that it come back before you. Dale can speak to if you have questions about where that is in their process, but it sounds like we're very close to acquiring a conservation easement with Pitkin County Open Space, the City of Aspen Open Space, and the Aspen Valley Land Trust. When that all happens, the approval for the subdivision would be vacated. So the property would not be subdivided. So there would be no need to file a plat. Hence the request to extend the deadline. So we've requested to extend it out for another 6 months to September 17, 2018. But I think Dale could help. I think the timing on where things are headed is sooner rather than later for the conservation easement.
Okay, Dale.
Thank you. I would predict that we will be done with this by December. The only reason that we're not under contract yet is that we've got 3 partners, and every one of them needs to review all the documents involving the contract and the exhibits to the contract, which include a draft conservation easement. Ryan and I have been over the contract. The other parties are looking it over, and all that has just taken a little longer than we anticipated. But I can certainly vouch for Stephanie that she has proceeded in good faith to give us time to take this to the City of Aspen, to the Aspen Valley Land Trust. We've discussed it in our negotiation discussions. So I would strongly support the request to extend this deadline.
But you said December, right? You said December, but so we've said extend to September. Do you think that needs to be extended beyond that?
How quickly we close the conservation easement purchase is one thing, but I would predict we will be solidly under our contract by September.
So September 17th is a good date. September, not December.
Correct.
Okay.
I misunderstood.
Yeah, no, I just, yeah. I guess. Right, okay.
The board have any questions? I think we're all familiar with this.
Just only that, just wondering why it needs to be extended. This is the second extension? Is that what you said? Is this just explain the process to me? And is it just that you're getting 3 other parties to review it?
Well, in other words, she would have to perfect her subdivision to stay within our deadline. We're hoping she doesn't need to do that, and the conservation easement would moot that need.
So there's a deadline when you have to file your final plat, and so that might not be necessary. So if we continue to the 17th, it's cleaner for Steve?
I, among others in this room, understand how long it can take to get a conservation easement in place.
Personal experience.
4 of us in this room worked on it, and it took much longer than anybody anticipated, but I completely understand when it takes longer to draft the language in a conservation easement. It's better to do it right and take the time, even if we have to do an extension. So I totally support this extension.
Make a motion to approve.
Please, and a second?
Second.
I have a motion and I have a second. Any further discussion? I'll call the question. All those in favor, please signify by saying aye.
Aye. Aye.
Motion passes 5-0. Thank you very much. All right, do we have open discussion, Mr. Peacock?
I think the only thing to update the board on is we did have a conversation with representatives from City of Aspen, the city manager and mayor, to talk about our next joint meeting.
Oh, we are going to talk about it today.
Oh, okay. I
That's
guess
good.
so, since we're
We
here.
got time. Let's talk about it.
And what we had talked about doing, where the housing discussion is not going to be ready in April, neither is the Castle Creek Trail project. But Patty and I did take the opportunity to look at the city's top 10 goals, and there were 2 that we have not spent much time talking about, and we thought it might be interesting just to really have time for the elected officials to discuss those. And the 2 that we were looking at was their goal around regionalism and their goal around having a people focus. And we thought that there's probably enough in those 2 and potentially a number of areas where we're already doing work that could be better coordinated that we thought would be worth a conversation. And so looks like we will try and do that meeting on April 10th. We'll probably do a similar format to what we did last time, where we try and have a meal together and a space. And it'll be really more time for the elected officials to visit with each other.
We'll do it outside of City Hall like we did before, or outside of our meeting room, where we can just sit down and hopefully do some relationship building with City Council. And staff, John and Steve will be Steve Barwick and John will be working on logistics of bringing the issues forward. When they talked about people, when we brought up their goal of around people, the city is interested in having more information about our Healthy Community Fund. And so we think that's a good opportunity for us to seek their support in the ballot question. And just to have time where we don't have PowerPoint presentations flashing on the screen, where we can intermingle and actually get down and talk about these issues on a more one-to-one base. Does that sound okay with the rest of the board?
I was glad that you elaborated a bit on people focus and regionalism. I was trying to think, what all does that entail? And it's an interesting headline for a conference.
Yeah. Well, it's two of their goals, and I think regionalism was their number 2 goal on their list. So
it's really talking about some of their top 10 goals and taking a deeper dive and seeing where we have some
where we can do some collaborative efforts.
Well, there's just very rarely issues or problems you can solve without working regionally, quite honestly.
So and just the fact we'll have the opportunity to just talk to each other, I think is a real positive. And so they were really excited in it. And then we will follow up at another date with the whole meeting on housing.
Yeah, I agree with that, and thank you, Patty, for setting that up. What strikes me is that if we do quarterly meetings, roughly 3 months from this one, we'll be in July. And so by July, we're getting very close to final deadline for language, for the ballot language for Healthy Community Fund. So I agree with what we're doing, and maybe an introduction of Healthy Community Fund, but let's make sure it's a larger topic at the July meeting so we can have some finality.
Right. Okay. And we may actually pull the housing meeting, well, probably July, John, don't you think? Another quarter for the housing meeting? Because there's still so much work that needs to be done there, I think.
Yeah, I agree. I'm just saying.
Yeah. So I think that's
future
good.
Topics.
Good timing. Okay. George, did you have something?
Well, I was just curious that we may want to have a meeting between this meeting and July if the housing's ready to go, because that's a topic that would take some time.
Yeah, and Steve Barwick said that he would like to see us address it sooner than later. So if that comes up, we'll have to see if we can get a date we can do that.
Yeah, it may be worth looking at just for the summer with elections coming up, every 2-month meeting instead of every.
Yeah, we'll see what happens. Where the city's going. Greg, did you have anything you wanted to say on it?
That's it.
John, did you have any other open discussion? Any other open discussion from the board? No? Steve?
Well, Cindy is here. Cindy, yesterday I could not remember when the CC4CA training starts. Is it at 12 or at 12:30? Because we had it wrong on our future agendas.
The steering committee starts at 10:30, and the rest of the commissioners and everyone are invited at noon.
Would you somebody just send us out a reminder on that? And it's at PAC 3.
Yes.
And it's for lunch if we get there at noon. And if we're on our best behavior, we get fed. Okay, thank you.
I knew that the lunch, eating lunch started at noon, and then I couldn't remember if we were going to do like a working lunch.
No, steering committee.
I thought that's what we were going to do, but I couldn't remember for sure.
Did you have any open discussion, Cindy, that you're so patiently sitting here with us? We've got you in front of us. Anybody? We got Cindy here, guys. So.
Okay.
Is there anything else? Okay, then I will entertain a motion to adjourn.
So moved.
So moved.
Motion and a second. All those in favor, please signify by saying aye.
Aye.
Aye. Good job. Thank you, Grassroots.
Thank you, Patty. Might be a record.
That was surprising for.
Boy, that was quick.